Good afternoon, everybody. Welcome to today's Health Law and Ethics Network seminar. I'm Professor Paula O'Brien from the Melbourne Law School, and I'd like to warmly welcome you to the first seminar for 2025. The Melbourne Law School stands on the lands of the Wurundjeri Woiwurrung people, and I pay my respects to elders past, present, and emerging. And I welcome any Indigenous colleagues here today. We're very pleased today to welcome our two speakers, Dr. Nitya Phillipson and Dr. Owen Bradfield. The topic today, as you know, is AI in healthcare, addressing legal, ethical, and practical challenges. So we're very pleased that Owen and Nitya are here. Dr. Owen Bradfield is the Chief Medical Officer of the Medical Indemnity Protection Society. He's a researcher at the University of Melbourne, and he's also the Deputy Chairperson of the Australian Institute of Health and Welfare's Ethics Committee. And Dr. Nitya Phillipson is the Head of Integrity and Governance at the Murdoch Children's Research Institute, having held similar roles in other institutions around Australia. So we're going to get started. So both of our presenters will present their separate papers, and then we'll have about 15 minutes for questions at the end. I know with this topic that we could spend much longer speaking, and so both the speakers would be very happy to hear from you after the presentation if we don't get to your question or comment. So we're going to start off with Owen and then go into Nitya's presentation. So thank you both very much.
Thanks very much, Paula. All right, great. Well, thanks so much for the kind invitation to present this afternoon, and thanks for everyone who's dialed in to join. So again, before I begin, I would also like to acknowledge the traditional custodians of the various lands upon which we're all gathered. For me here in Melbourne, it's the Wurundjeri Woiwurrung people, and I pay my respects to their elders past and present, and of course warmly extend that respect to all First Nations people who are joining or who might later watch a recorded version of this presentation. So as Paula mentioned, I'm the Chief Medical Officer of MIPS, one of the main medical indemnity insurers here in Australia. And probably over the last 12 months, we've really noticed an increase. Well, probably about 12 months ago, we first noticed an increase in the number of calls to our medico-legal advisory service from clinicians who were starting to use AI tools in their practice to generate medical records or reports. And as I'll mention in my presentation, really since then, the use of generative AI has skyrocketed in Australia, but it does create some legal, ethical, and practical issues, which I'll touch on this afternoon. So there are a number of different applications for AI in healthcare. Some are still probably kind of magic faraway tree type of stuff, but others, are here and now. So some practitioners are using AI. So, for example, radiologists are using AI to assist in diagnosis, in medical imaging, mole mapping. Pathologists are using AI. But where it's really taken off has been for the generation of medical records. And so we call these tools AI scribes. And so the way these AI scribes work is that they essentially record a clinical encounter and then convert the audio file into a text transcript. So you get a complete verbatim transcript at the end of the consultation of what happened during the consultation. Some of the tools then redact identifying information from that transcript, and that's important when I get to discuss later on what some of the privacy implications are of these tools. And then the software then, uses the various models or algorithms to then generate a summarized medical record, or it might be a discharge summary or a referral letter or a report in the case of, for example, an independent medical examiner. And so there's a number of benefits to the use of these tools. There's been quite a lot of research that shows just how much of a burden, an administrative burden, creating medical records can be for clinicians. But we know how important medical records are, not just for continuity of care, but also, in the defence or prosecution of legal claims as well. Um, some overseas research shows that the use of these tools can improve productivity, can increase work satisfaction for clinicians because it means they can spend more time with their patients rather than creating records at the end. Um, and because the records are very, very detailed, and provided that the clinician has input into the AI output, they can also be more accurate and therefore a better record of what happened, and that can improve patient safety. And so just to, I guess highlight some recent headlines from the medical press. Back in October last year, there was a survey conducted of GPs that were using AI scribes, and it found that whilst unfortunately GPs weren't necessarily getting home any earlier at the end of the day, it did mean that they were able, because of the use of these tools, sped up the time in which it took them to generate records. It meant that they were able to give back that time to the patient during the consultation. And anecdotally, from colleagues that are using these tools, they're very well received as well by patients. And so just again to highlight the kind of exponential rise in the use of these tools over the last 12 months. So in May last year, it was estimated that about 4% of GPs were using these tools, whereas as at October last year, more than 8% of GPs were using an AI scribe. So the use had sort of more than doubled in a 6-month period. And as at October, Lyrebird, which is one of the companies that markets an AI tool in Australia, said that its product was being used in approximately 10,000 consultations per day. So that's just one provider, and that was, nearly 6 months ago now. So one can only assume that since then, its use has continued to rise. But there are a number of medico-legal considerations, I think, to be alive to when using these tools. And in my view, none of these are barriers to the use of these tools, but I think just things that are important for clinicians to be aware of, and I guess for lawyers to be aware of as well if they're advising clinicians about the safe and compliant use of these tools in clinical practice. So the first, I guess, sort of really relates to their regulation here in Australia. And so the Therapeutic Goods Act determines whether or not a piece of software is considered to be a medical device or not. And in the case of an AI scribe, where its primary purpose is to generate a record and it's not being used as a tool to assist in clinical decision making, it doesn't currently meet the definition of a medical device, and so therefore is exempt from TGA registration, and essentially means that they are unregulated tools in Australia. And so that, for me, really just highlights the importance of clinicians doing their due diligence before considering implementing the use of these tools in their practice, just to make sure that they understand what it is that the tools are intending to do, that they're not being used to assist with clinical decision making, that perhaps clinicians consider a trial period or a demonstration or training before purchasing a license to just make sure that they do what they say they do and they're fit for purpose and they meet the clinician's clinical needs. And also, that they check any license or user agreements carefully just for any clauses that might have implications for the clinician's practice, such as indemnity clauses where the software vendor might seek to shift responsibility to the clinician should the software not work as intended. So I think that's one of the first things for clinicians and lawyers to be aware of. The second, I think, is just the importance of obtaining consent. And so just thinking back to my initial slide where I sort of highlighted how these tools work, uh, they work by capturing speech. So essentially, they're a listening device. And throughout Australia, each state has surveillance devices legislation that regulates the use of listening devices. So in some states, highlighted red in this slide, it's a criminal offence to record a conversation, a private conversation, without the consent of a party to that private conversation. But even in those states where it's not a criminal offence to record a private conversation without the consent of a party to the conversation, it may well be an offence to use or publish material that's been obtained from the use of a listening device where you haven't obtained consent. So, irrespective of the jurisdiction in which the practitioner is practicing, it's important for clinicians to obtain consent from patients to the use of the AI scribe before proceeding with the consultation and using an AI scribe. And a very common question that we get asked at MIPS is, well, does that mean I need to get consent prior to every consultation? And in my view, the answer is yes, because any consultation that occurs without consent could amount to a criminal offence in some jurisdictions. And so therefore, I think you need to get consent prior to every consultation. That doesn't necessarily mean that that consent discussion needs to be detailed prior to every consultation. I think prior to the first consultation, there would be a conversation around what the purpose of the software is, how it's designed to work, that the consultation will be listened to and recorded as part of the generation of the record. And then prior to subsequent consultations, that consent process may be limited to simply reminding patients about the use of the AI scribe and importantly, giving patients an opportunity to ask questions and to opt out if necessary. There was a case that looked at listening devices in the context of clinical consultation over 10 years ago now, and that was in New South Wales. And this was a case where a patient secretly recorded a consultation using a device which I gather is similar to the one that I've got a picture of here. I don't know that it was necessarily an Olympus device, so I'm not trying to besmirch the reputation of Olympus here at all. But essentially, in that case, the question for the court was the GP's consultation a private conversation? And the court said it was, because it wouldn't have been reasonable to expect anyone else to overhear that consultation or that conversation. And so therefore, recording the consultation without the GP's knowledge or consent was a breach of the New South Wales surveillance devices legislation. And I think there's no reason to suspect that a similar approach wouldn't be taken by the courts if a practitioner was to record a consultation without the consent of a patient. So just moving on, so we've talked about consent and surveillance devices legislation. It's also important to think about some of the privacy implications as well that can arise from the use of AI scribes. And importantly, data retention is one of them. So again, thinking back to that initial diagram where I explained how, in broad terms, these scribes work, the scribe will generate a transcript, a text transcript, verbatim transcript of the entire consultation, which will then be rinsed through this algorithm or model to generate a summarized output. And so I guess in a private clinical setting outside of ACT, Victoria or New South Wales, the Privacy Act would generally apply to those consultations. And under the Privacy Act and the Australian privacy principles, clinicians would be required to delete or de-identify any personal information that's no longer required for the primary purpose for which it was collected. So if you've got a verbatim transcript and you've now generated your summarized AI output and you no longer need that transcript, then it should be destroyed. However, in ACT, Victoria and New South Wales, there's specific health records legislation that requires health information to be retained for at least 7 years from when a patient was last seen or until a child reaches the age of 25, which raises a bit of a conundrum about what to do with the text transcript. Because if the text transcript isn't de-identified by the software vendor in real time as it's being generated, and if it contains personally identifiable information or health information that doesn't find its way into the final output, then it does raise a real question about what should happen to that text transcript. It's probably not ideal that there would be two versions of a record, a medical record in existence. One that would be on the medical record and another where you would save somewhere these text verbatim transcripts. I think it's very challenging for clinicians, and my view would be, that as part of checking the AI-generated output, that you also check the transcript just to make sure that you're satisfied that there's no clinically relevant health information in that transcript that hasn't found its way into the AI-generated output. Another issue to be mindful of is overseas transfers. So fortunately, most of the AI scribes that are in commercial use here in Australia are Australian based. And so therefore, health information is stored and or processed here in Australia. But sometimes if an overseas product is being used, then there may be overseas data flows. And as many of you would be aware, under the Privacy Act, it's a requirement to ensure that any overseas jurisdiction to which personally identifiable information might be transferred has laws or protections in place that are broadly similar to those protections that we have here in Australia. If that's not the case, or if you're unsure, when in doubt, you would need to get consent from patients to the overseas data flows. Another really important thing to think about is secondary use. So whilst the primary purpose of the use of an AI scribe is to generate a health record, some AI tools might in fact collect that information for AI scribe learning purposes. So if we think of ChatGPT, for example, when you enter information into ChatGPT, that information is stored by OpenAI, which is an open source overseas-based company that then the information that you enter can then be accessed potentially by other people who might ask ChatGPT similar questions. So again, really important to understand before using an AI scribe whether there are in fact any secondary uses for learning purposes. And one of the other really important issues is to check for accuracy. This isn't only a requirement under the Privacy Act, but also the Medical Board of Australia's Code of Conduct requires that medical records that are generated be accurate. And so, no AI tool is 100% accurate yet. They probably never will be, but even if they were, other things can there can be other reasons why an AI output might not be 100% accurate, and that might be because you need information from other sources, such as test results or specialist letters, in order to be able to finalize and generate an accurate record. Or it might be because the voice recorder doesn't clearly capture maybe there's interference or background noise, and so it doesn't accurately record the words that are being spoken. So there's a number of reasons why it's absolutely critical for clinicians to always check the accuracy of an AI generated output, and failure to do so could have, of course, patient safety implications if it means that the medical record generated is wrong. But also we've seen situations where it can also potentially result in a privacy breach if information is sent to the wrong recipient, for example, because the name and details of the recipient are incorrect. So my rule of thumb is that there must always be human input into each and every AI output. So I'm just mindful of the time. So what I'm going to do is just scroll ahead to a couple of cases, which I think are really interesting. So we don't really have any cases yet in healthcare, at least not publicly available cases that I'm aware of. There have been a couple of scenarios where generative AI has been used. And there's been two cases that I'm aware of involving lawyers here in Australia. One was a Melbourne lawyer last year, and the other was a New South Wales lawyer last month. And in both cases, the lawyers, and I'm summarising this, I'm not going to go through all the details, but in both cases, the lawyers used specific AI software marketed to the legal profession, which were used to generate submissions in court proceedings. And in both cases, those submissions contained case citations which were fictitious. So in both cases, the generative AI software had just created fake case names. And I can remember I used ChatGPT once to, well, I've used ChatGPT quite a lot, but I do recall using it once to ask a question and to ask for sources. And it gave me sources, and I was quite surprised because I hadn't come across them on Google Scholar or other search engines. And when I copied and pasted those references into Google Scholar, it came up blank. So I then had to ask ChatGPT, are you sure these references exist? And it said, no, I'm very sorry. These are just examples of what what references might look like. And so in both of these cases, the lawyers fell foul of the fact that it had generated fictitious cases. In both cases, the judges then retired into their chambers with their associates and proceeded to attempt to find those cases. And when they couldn't, and the case came back before the court, inquired of the lawyers how those cases were generated, and when it was discovered that the submission was generated using AI, the lawyers were both referred to their respective legal complaints commissions. And in the case of the lawyer here in Victoria, that then resulted in the Legal Services Commissioner generating some guidance for lawyers on the safe and professional and ethical use of AI. And just one more case, there was last year an investigation by the Office of the Victorian Information Commissioner into a child protection worker who was employed by the Victorian Department of Families, Fairness and Housing. Or is it Fairness, Families and Housing? I can't think it's Families, Fairness and Housing. And in this case, the child protection worker had used ChatGPT to generate a child protection report. And when the judge in the children's court received that report, and that report was considered by the court, it contained a number of errors. Sentence structures, like there was punctuation missing, sentences were incomplete, and the report generally didn't follow the usual template that would have been expected. And again, on further investigation, it was revealed to the court that in fact ChatGPT had been used. And so the Deputy Commissioner of OVIC investigated the matter and found that there were really a couple of significant problems with this. One was that the accuracy of the output hadn't been checked. But secondly, there'd been a significant privacy breach because personal information about the child's circumstances, the child's family, and I understand from the report that names had been inputted into ChatGPT. that meant that personal information had been disclosed to an open source, overseas company that potentially could be made available to other users using ChatGPT in the future. So the outcome was that a number of recommendations were made by the Deputy Commissioner, one of which was that the use of ChatGPT by child protection workers should be banned. So just one more issue I just wanted to touch on, and this is a a practice note from the Chief Justice of the Supreme Court of New South Wales. And this just relates to the use of AI in court proceedings, and specifically in relation to expert reports. So it's only been, it only commenced just over a month ago, and the practice note requires that AI not be used in the preparation of an expert report or part thereof without prior permission from the court. And that certain information has to be disclosed to the court either in the application for leave to use AI, or if leave is granted, certain information must be disclosed in the report to just clarify, what tool was used and which aspects of the report were generated using AI. So that's probably all I've got time to talk about. So thanks
Uh,
very much, Paula.
Thank you, Owen. So we'll go straight into Nitya's presentation.
Thanks so much, and thank you again for inviting us to be here today. It's really great to be able to talk about AI in this space. And I too would like to acknowledge the traditional owners of the land on which we meet. I'm here in Flemington, so on the Wurundjeri lands of the Wurundjeri people of the Kulin Nation, and pay my respects to elders past and present. So I'm going to be talking a little bit differently, but very related to what Owen's already described. It's really the use of AI in health and medical research. So I work in a Health and Medical Research Institute, and so I'm here to talk about it through that lens. Very quickly, I'd just like to confirm my relevant interests. I am an avid user of Gen AI. I don't think that's a conflict of interest, but more a point of distinction. But I do chair the AI steering committee for the Institute that's setting the direction and strategy for the Institute. But I unfortunately don't have any shares in ChatGPT or NVIDIA or anything like that. So can say that I don't have any financial or other conflicts of interest to disclose. Okay, so what are we going to do in the next sort of 15 to 20 minutes is a whistle-stop tour of how we know AI is being used in this sector, the opportunities and risks this presents, and what we're kind of telling our research community that they should be doing about this new technology. I'm going to make a couple of assumptions. The first, you know what sort of AI is, otherwise we're going to spend 15 minutes talking about that. And the other is that this is a bit of a focus on generative AI and large language models, and I are sort of consistent in that, but that there are other AI technologies that are worth thinking about, and maybe we can talk about another day. Okay, so how do we know AI is being used in this sector? Well, I like to split it up into two different buckets. The first is how we use AI to support doing research. So in that instance, I'm talking about how we consume it, how we use it to do our everyday research work, and that's why there's a burger and a milkshake there. Because the other way we do it is by developing and adapting it as part of our research. So in that instance, we're talking about the chef. They're making it rather than just using it or consuming it. So I'm going to touch on both of these cases and just give you some ideas of a bit of a flavour of how it's being used. So when it comes to supporting research or consuming, there's a couple of different areas that are really emerging that's quite exciting. The first is in how it's being used to support ideation of research, and how it's being used to review the literature, but also how it's being used to generate research questions and hypotheses. And this is a still from a great video that Monash University put out looking at how we can use ChatGPT to actually develop our research questions if you know the research area, and that's a big if. But just today, Google announced that it's just released co-scientists, so apologies I didn't get time to update the slides. And that too is being developed to help researchers develop their research questions and understand the gaps in knowledge. The next and probably more common use is around writing. So it's being used a lot to support and do writing and research. And that can be from a range of different things. It might be emails or terms of reference, how I sometimes use it, all the way through to generating ethics applications, grant applications, and journal outputs. And recently we're working out that it's not just being used to write, it's also being asked to review those documents. So we're putting in grants maybe into these tools and asking them to do a review report so that we can then hone and develop our applications. And the final, I should say that is not permitted by the ARC, and that's why that link is there. So I'm happy to share these slides so you can take a deep dive if you want to. And the last area is around supporting participation of research. And this genuinely, I think, is one of the most exciting opportunities that these models provide. And that is through the much more cost-effective use to translate our documents. You know, we have here, particularly in service, we provide culturally and linguistically diverse participants. And it used to be very expensive to translate documents into other languages. And that cost has been reduced because now we're just asking services to check outputs rather than to do that work in its entirety. I'm also seeing it being used to generate some great videos, cartoons, PowerPoints to support consent in research. And I just reviewed my first ethics application the other day that actually proposed using an AI mental health chatbot to support immediate participant distress. So normally we'd say to people, if you're feeling distressed, go and talk to your GP, which of course is really important and very, very sound advice. But if it's in the middle of the night or you've got a bit of a wait to see your GP, they're also suggesting these sort of mental health chatbots to support more immediate research support and distress support. So that's an interesting area. And I want to say that this is particularly useful if you work with children, as I do. When you want to simplify language, it's pretty good at that. And it's really useful if English is not your first language. And I do think it's worth saying that the research community is broad. And we do, of course, have researchers who don't have English as their first language. And it's opening up doors that have been closed to them before. So I wanted to give you a live-ish demo because you should never do anything live on Zoom. So this is the ChatGPT interface. Hopefully you are, or hopefully you're not, I don't know, depending on where you stand, familiar with this technology. And what I wanted to show you was how it could be used to simplify language. So for those of you who don't know, the NHMRC, or the National Health and Medical Research Council, has a consent form template. It has all this wording in a template that is meant to be helpful to researchers to go and generate consent forms to their patients. I'm going to give you a few seconds to read this consent template wording. And you're all lawyers and doctors, so you'll be very quick, but I'll give you a sec. That's a long sentence. That first sentence alone is really challenging. So I asked ChatGPT, please, pretty please, could you rewrite it to the reading age of a 12-year-old? And it had a go. And that's in the quotation there. Have a read of that. So I thought this did a pretty good job at making that easier to understand. I actually better understood that sentence having had ChatGPT explain it back to me. And then just to see how far it could go, I then said to it, can you please, again, because I always say please to AI models just in case, can you please translate this into the 3 most common languages spoken in Melbourne that isn't English? And not only did it identify those 3 languages, and I checked this is correct, it had a go at translating it. Now, I don't speak any of those 3 languages, and I'm sure there's someone on the Zoom that does. I'm sure it's done not the best job, but at least we've now got something we can take to our translation services and get them to check and edit rather than them spending hours doing that from scratch. So it's quite exciting that it can do this. And then just to push it one step further, because I couldn't help myself, I said, okay, could you make me an image or cartoon? And it had a go and it drew me this picture of Alex, and you think, oh, that's quite nice, until you really look at the photo and the image, and you realize that research is spelt wrong. It's research, and participant is participant. And I am yet to ever find a clinician who wears one of those things on their heads, and they're all male and they're all Caucasian. And so you go, well, okay, we've taken ChatGPT to its limit of usefulness. But I just wanted to demonstrate that it can be quite helpful at checking consent language, checking language, and maybe eventually providing some images to support consent models in children in particular. Okay, so that was a very brief overview of how it's being used as a support tool, and I'm sure I've missed use cases that I welcome you to tell me about. The next sort of area I wanted to touch on is how we're developing or adapting it. It's how we're being chefs and creators of these wonderful technologies. I wanted to give two examples, but just to acknowledge that we've been doing this for a really long time. Health and medical research has been using machine learning in particular for decades. So this might feel new, but it's actually not that new. And the one study I wanted to point to was a beautiful bit of research done by the Black Dog Institute, and there's links to the publications on the bottom, which combined my two favourite things, which is AI and social media. So it felt like two disruptive technologies in the one paper. You'll note that this paper was published in 2014. This happened a decade ago. And what it did, it collected Twitter posts using a public API, and then used human coders and machine learning to look at concerning suicide-related posts. And they found that actually machine-learned classifiers were correctly identified about 80% of the time as the human coders. So it was actually quite good at recognizing suicide-related tweets that were strongly concerning. And it actually got better the more data that was fed into the model. It also demonstrated that these tweets, I think they're called something else now, but tweets back then have a unique linguistic profile. And we can use that to really support directed advertising. So the idea was that if someone posts or reads a post about something like this, that they are directed to either the Black Dog Institute or Beyond Blue or a help support service, which I think is really an incredible use of these technologies. In the interest of time, I won't go through this one, but I will pass these slides on afterwards. But it's also being used in very cool ways in EDs in the UK and across the board, which is exciting. But how are we using it at the Institute? Well, like I said, we've been doing this for a long time, but there have been some, I guess, in the last few years, interesting cases that have come up. And we're definitely using it to look at vaccine adverse events by scanning social media surveillance. We're definitely looking at it in the rare disease diagnosis, where we know we need a lot of heavy lifting in that space, as well as maybe using it in an app to identify baby movements and cerebral palsy and stem cells and beyond. So we're using it for a very diverse set of uses, and that is both excellent because it means that we're embracing this technology, but also as someone who's got the words governance in their job title, makes it a reasonably challenging thing to sort of govern. But we have had a crack at looking at it across the campus, and colleagues across the campus we produced this survey about a year and a half ago now to look at how our clinicians, our researchers, and our educators are using it. And we're going to be publishing that work soon. But we're using this to inform our governance frameworks and models. Because I can't really talk about AI without talking about the inherent risks. It seems a bit one-sided just to talk about all the positives, and you'll be pleased to know that Owen and I are really coordinated in this, and we've come up with similar issues from a different lens. So the first is around privacy. I mean, Owen's really beautifully touched on who owns this data. But for us in research, who owns the IP related to that data too that's being fed into these models? We've also already touched on consent. I think it's a bit difficult in the research space because we have such prescriptive consent procedures. Terms and conditions we know do not constitute consent. We're not even going to debate that. But if we have to include in consent forms every single use of AI, which again we've been doing for decades, in every technology, in every medical device we're probably using, are these consent forms going to just become so cumbersome that consent fatigue sits in? So I think we're going to have to really think about how we approach consent with these technologies. And then the third one I want to touch on, which is how it's sort of emerging that we might be accidentally propagating unethical research. And that's because, and I saw, and you had a slide to this, that there are tools that we don't exactly know how they're trained or working. And I sit on an ethics committee and I peer review papers, and I don't understand how these models work or are being developed, but I'm being asked to review them. And I often refer them on for other expert reviews, but it is really challenging, especially when sometimes even the researchers don't know how they're working. And, as ethics committees, we're being asked to situate ourselves in these very unimaginable risks, consequences, uses. And I'm not going to lie, the ethics guidelines haven't kept up, and I don't blame them for that. The technologies were coming out thick and fast. But we do certainly need to think about how we're addressing this, because there have been some pretty high profile cases. I'm not defaming anyone here. This is in the public domain, but this is a case of some fairly questionable research that was undertaken in conglomeration with a military research conglomerate in China, and particularly the role of an academic who is developing methods to detect the face of Uyghurs, the ethnic minority Muslims in China, and how we could better pick up their facial features. It is now very clear that this was very likely used to track ethnic minorities and support state-sanctioned persecution. And both organisations have launched really extensive reviews and should be commended for the work they're doing in this space. But the question remains, how do we, as a society, a committee, a body of researchers, decide how we use these technologies and the on-use, the secondary use, as Owen put it, that could be unintended. So there's a couple more to go. Because there are quite a few risks that we need to think about. Researcher risks is an interesting one. I, the other day, used ChatGPT to help me with an abstract, and I was very honest about the fact that I did that. But I don't know how the reviewer at the other end is going to view that. I don't know if it's going to be professionally bad for my reputation. And so I'm a little nervous about what this is going to mean reputationally for researchers. I also think it's going to be interesting how we evolve the professional responsibilities of researchers. It used to be a really important skill to be able to read papers and summarize them. I don't know if that's still going to be considered an important skill. I'm sure we could talk about that a lot, but we're going to have to think about what it means professionally to be a researcher and what tasks we can genuinely delegate. I work in the integrity space, and my job just got a lot harder. It used to be when I wanted to find a fabricated data set or something, I would look at something like this image you can see where that's a Western blot that measures the amount of protein in something. And I would look at them and I'd say, oh, look, they've duplicated that image, they've flipped it, and you can see they haven't cut and pasted it very well. And that's how, honestly, we would detect manipulated images in research. With the advent of AI and synthetic data sets and AI-generated images, I don't think I'm going to cut it anymore with just me looking at documents and images and going, that doesn't look right. So we are definitely, the sector is working to detection tools to detect fabricated data. But in the meantime, I think it's going to be really tricky to detect fabricated or falsified information. And Owen's already told us that ChatGPT in particular hallucinates, and even the more bespoke legal applications hallucinate, make up citations, make up case law, make up references. In the research world, that is plagiarism if you miscite someone's work or don't credit them with citation. And that's quite a serious research integrity matter. And we're certainly seeing it amplifying misinformation depending on the sources that it's accessing. And so the last one I want to talk about is bias. Because I think it's something that we all know in our minds that AI is biased, right? We kind of tell ourselves that we know it, but it's about what we're doing about it that's sort of troubling me. And hopefully you can still see that. It's really about training data in is what's creating the bias. If a model is trained with biased data, it's going to have a biased output, and that there's potential for that to be amplified through these AI models. So I want to tell you about a paper that was done in 1990. I was 6 when this was published. This paper from a long time ago found that pulse oximeters, they're the devices that you put on your finger to measure blood arterial gases or the gas levels in the oxygen levels in your blood, doesn't work very well for people with melanin in their skin. So it overestimates for Black patients than it does with white patients. This study has been replicated 2 more times, yet these devices remain in ubiquitous use without modification. And it's because we don't maybe have the regulatory framework that kind of calls out bias and makes us do something about it. We are trying, we are getting better, and I'm optimistic about the future, but we can't just keep on talking about bias as if it's this abject thing, because when COVID hit, what we saw was a significant discrepancy between what the readings were and what they should have been. And this was linked to a delayed or lack of treatment for Black COVID patients. So these aren't academic things, they are decisions that are certainly going to be harming people. And it's something that we can't sort of wave our hands at anymore. I think we need to really sit in the space of what these technologies mean for bias and recognize what needs to be done. So I've sort of given you a bit of a whistle-stop tour. I've told you that it's great and that it accelerates things and improves research and it makes it more accessible because we can translate things. And then on the other hand, I've told you, but it's risky. There's problems for the ethics and integrity of the research coming out of it. And actually, maybe it's going to drive inequality. And I know I'm not giving you a straight answer here. And that's because we're asking ourselves really hard questions. And then the overlying question of all of this is, how do we legislate and govern ethical use of these devices when we can't even decide whether they're good or bad in a given moment? And I can tell you that we've tried, and it is chaotic. This is just a snapshot of some of the regulations. I actually had like 40 more in there, but it was making me anxious. So I've cut some out, and there are, discipline-specific guidance. We've got the EU Act, we've got the Australian voluntary standards that are soon to be mandatory guardrails. We've got I've got institute policies there. We've got ARC policies. So we are trying to regulate these technologies, but kind of probably still in our infancy, getting to an outcome. And so what I come back to is, what does this mean for our patients, our families, and our communities? What do they want to know? What do they need to understand? And how can we work together to use those technologies safely? So we've come up with some really high-level technologically agnostic guidance. And they're pretty similar to what Owen's already talked about. You have to take accountability for your outputs. You have to disclose when you've used it, particularly to your participants. You have to keep a log, a bit like the last Chief Justice's recommendations, and you have to keep up to date. And I know that's asking a lot of our research community, but we're in it together now, so we need to keep up together too. And we've got some fairly hard don'ts. So you cannot put personal, sensitive, or commercially sensitive information into an AI model unless we have told you it's okay to do that. And in doing that approval process, we're going to consider many of the things that Owen's already talked about, which is great. We're going to make sure you don't solely rely on AI, and we're going to beg you to not ignore biases. And then to keep on thinking about data privacy. Would you want your child's information in that model? Would you be happy with it being used in this way? And what do your patients, families, and communities think? So in the spirit of doing what I preach, practicing what I preach, I would like to acknowledge that I used a little bit of AI in this talk. I did it last year and I've adapted it since. I used ChatGPT. Here's the prompt that I use. And I used this as a starting point to generate some of my ideas, and then took some very clever sentences and put them in my PowerPoint presentation. But there are a million different ways you can acknowledge its use, and I've got them down the bottom. And I welcome you to, explore these technologies ethically and responsibly, and continue the dialogue and ask questions if you have any. So thank you.
Thank you very much, Nitya. Thank you both very much. Just fascinating presentations, raising, lots and lots of interesting issues. And we obviously, like I said, could have gone on for much longer, but I do encourage people to reach out to Nitya and Owen if they'd like to continue the conversation. Thank you very much, everyone, for joining today. The next Helen seminar is the first Tuesday of April, and so we welcome you back for that. If you haven't joined the Helen mailing list, please jump onto our website, and down the bottom of the landing page is a place where you can go in and ask to join the Helen mailing list, and then you'll receive emails about the seminars and other things we have going on. It's a very light mailing list. We won't be bombarding you with lots and lots of information, but just about all the things that are going on through Helen and on the University of Melbourne campus in relation to health law and ethics. So thank you very much to our speakers once again, and thanks to everyone for joining today.